David R. here. Today I'm going to talk to you about this book, Gideon's Trumpet by Anthony Lewis. This book is about the famous Supreme Court case Gideon v. Wainwright, 1963. I structured this video with a series of questions that I will answer throughout. Thought that might make things a little easier. And in some cases, I will flash text up on the screen where I read quotes. First off, who was Clarence Earl Gideon? Clarence Earl Gideon was born August 30th, 1910 in Hannibal, Missouri. His mother was very strict, and he claimed his stepfather really didn't like him. So at the age of 14, with only an 8th grade education, Gideon ran away from home. And this is, I would say, where he began his life of crime. Now, he was in and out of jail, in and out of prison throughout his life. That's why when we get to the case itself, Gideon v. Wainwright, you can understand why he was the usual suspect. How did Gideon v. Wainwright come about? Well, it came about when Clarence Earl Gideon was accused of breaking into the Bay Harbor pool room in Panama City, Florida. Someone claims to have seen him steal cash, steal wine, steal beer. I even think Coca-Cola was missing too. Gideon was charged with breaking and entering with an attempt to commit petty larceny. At his trial, he requested a lawyer. And the judge said, well, you can't have a lawyer because it wasn't a capital case. So he couldn't get a lawyer. He had to represent himself. And obviously, not really knowing the law so well, Gideon lost. He was sentenced to 5 years in prison. So what did Gideon do once he got to prison? Well, he started learning about the law. He obviously could read and write, and an 8th grade education in that era was probably okay. Probably wasn't like an 8th grade education today, but back then, I'm sure he could do something if he wanted to. He learned about the law. He wrote a writ of certiorari to the Supreme Court of the United States, and it was accepted. Now, a writ of certiorari orders a lower court to deliver its record in a case so that the higher court may review it. So what two Supreme Court cases were similar to Gideon's? Well, the first one was Powell v. Alabama, and this one, the Supreme Court ruled that the state of Alabama was required to appoint counsel, if needed, in capital cases where the death penalty was involved. The second one was Betts v. Brady in 1942, and this is one where the Supreme Court said that if there were special circumstances, perhaps the state would have to appoint a lawyer to the defendant. Gideon didn't have either of these characteristics in his case, so he was forced to represent himself. Why did the Supreme Court agree to hear Gideon's case? Well, since Betts v. Brady, many scholars, even people within the Supreme Court that themselves, wanted to overturn Betts v. Brady. They didn't think it was right. They didn't think it was humane. So this had been building for a while. They're just kind of waiting for a catalyst, and that's where Gideon came along. What happened when Gideon and his Supreme Court appointed lawyer, Abe Fortas, went before the Supreme Court? Now I'll read this to you. Fortas began his opening statement like this. This case presents a narrow question, the right to counsel, unencumbered by extraneous issues. The charge was a felony, not a lesser offense. Gideon's intelligence was conceded. He had unquestionably made a timely request for counsel, and this demand was for a lawyer at his trial. He went on to say that, I believe this case dramatically illustrates that you cannot have a fair trial without counsel. So what was the defense's argument for keeping Betts v. Brady? Well, the defense, Bruce Robert Jacob, he represented the state of Florida. He offered 8 different reasons, but I'm only going to list 4. The first one is this. There is no historical basis for requiring states to automatically appoint counsel in all cases. The 14th Amendment does not impose upon the states any uniform code of criminal procedure. And the third one, the Due Process Clause is a broad, inexplicit provision, and it is not susceptible of being reduced to a mechanical or fixed formula. For if Betts should be overruled by this court. As many as 5,093 hardened prisoners may be eligible to be released in one mass exodus in Florida alone, not to mention those in other states. What was the Supreme Court's response to Betts v. Brady? Well, they overturned it. They did exactly what the lawyer for Florida didn't want to happen, but they did it anyway. And Gideon won his right to a lawyer. So what happened when Gideon was retried in Florida? Gideon was retried in the same court by the same judge, except he had a lawyer, Fred Turner. Fred Turner did a magnificent job in representing Clarence Earl Gideon. For one, he did a little bit of investigating beforehand. He found out that there were advertising signs in the window. If somebody did look in, they weren't able to see somebody committing a burglary because the signs were in the way. Also, the windows were too high, so that wouldn't have happened either. He cross-examined the cab driver, a guy named Preston Bray, and Preston was there picking Gideon up when supposedly the crime had happened. He said Gideon's pockets weren't full of money. He didn't have any wine or beer on him, supposedly that he had stolen. So he called other witnesses as well and found out that possibly a guy named Henry Cook might have actually committed the crime, but tried to blame it on Clarence Earl Gideon. The jury deliberated for a very short time, and Gideon was found not guilty. So what did Gideon do right after the trial? Well, he went right back to the same place he was accused of breaking into. Anyway, how did this case affect future cases? Well, it affected them because now a person who is too poor to obtain a lawyer could ask for one and get one. Justice Hugo Black summed it up like this. He said, "Lawyers in criminal courts are necessities, not luxuries." I believe that that sums up this book, and it sums up this video as well. You can also learn about Gideon B. Wainwright through these lectures here, especially the very first one on litigation in the American legal system. This is where I first heard about Gideon B. Wainwright. I never knew about the case before. Anyway, talk to you later. Bye.